Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing new proposed federal cybersecurity legislation and the civil liberties implications of those proposed changes. Bill C26 was introduced in the House of Commons in June of this year, but it's received very little publicity so far. The proposed changes to the law would amend existing legislation to afford the Cabinet and the Minister of Industry additional powers. Now, cybersecurity is a very important issue for Canada from both an economic and national security perspective. Cyber warfare by hostile states, ransomware attacks by criminal organizations, and identity theft and hacking are all very important public policy issues. However, some civil liberties organizations have raised concerns about how Bill C26 could threaten privacy rights. The organization I work for, the Canadian Constitution Foundation, is one of those organizations. How do we balance concerns over security with our civil liberties? Here today to discuss this are two experts. Brenda McPhail is the Director of Privacy Rights at the Canadian Civil Liberties Association, and Rosa Addario is Communications Manager with OpenMedia. Thank you both so much for joining me today. Rosa, let's start with you. Can you explain to me at a high level what Bill C26 does? What are these amendments that are being proposed to pieces of legislation that already exist?
Definitely. Thanks so much for having me, Christine. So Bill C26 is yet another fumbled attempt from our government at privacy and security legislation. So in two parts, it amends the Telecommunications Act to promote security within our telecom sector, which is, a goal we can all agree with. But it does so through an unjustified and overly expansive power from our government and our spy agencies. It also creates new legislation, the Critical Cyber Systems Protection Act, that authorizes Canada spy agencies to collect and share sensitive data about Canadians in ways that they never have before.
Brenda, is there anything you want to add to, at a high level, what these proposed changes in Bill C26 do?
Sure. So in the new Critical Cyber Systems Protection Act, which is a mouthful, the act basically has the very sound intention of creating a framework to provide for protecting critical cyber systems and services that are fundamentally vital to national security and public safety, as you mentioned in your intro. But it also gives federally regulated sectors and the heads of those sectors, like banking or telecom or energy infrastructure or transportation, the ability to designate services as vital and therefore require operators to create cybersecurity plans and programs, which is good. Then share that information with a wide range of actors, which is less good. Necessary sharing for cybersecurity, but no sort of framework to limit it. And a really big program of monetary administrative fines for noncompliance.
Wow. So, Rosa, your organization, OpenMedia, as well as the CCLA and my organization, the Canadian Constitution Foundation, we've all outlined, along with some others, some of our concerns with the legislation in an open letter that was sent to Public Safety Minister Marco Mendocino. Now, I want to go through some of those concerns. The first is that Bill C26 could open the door to these new surveillance obligations for private companies. So how does the law do that, and why should we be concerned about it?
So Bill C26 could compel private companies like internet service providers to collect evidence and information against people in Canada. Because the bill provides greater roles for Canada's spy agencies and enables more data sharing, there's a concern that the data that these private companies are forced to provide on their customers will be used in untold and unseen ways that are completely unprecedented. And this would all occur outside of the normal parameters of democratic accountability. So we're looking at no parliamentary oversight, no accountability, and very limited regular judicial oversight. And far too much is only within the hands of the industry minister and our government.
Brenda, we've only got about 30 seconds. Anything you want to add to that surveillance obligation on private companies?
I think the wording of the bill is really instructive. It allows the government to secretly order telecommunication providers to do anything or refrain from doing anything the minister thinks is necessary. That's a very broad scope.
Yeah, and I think it would leave a lot of people concerned. We've got to go to commercial break now, but we will be right back to discuss some of the other potential problems in this bill that you've outlined in that open letter. We will be right back. Welcome back to Canadian Justice, where we're discussing proposed federal cybersecurity legislation, Bill C26, and the civil liberties concerns around that proposed legislation. Now, Brenda, you have said that in this open letter that Bill C26 allows the termination of essential services by secret government order. Can you explain what that means? Like, what types of services could be cut off and on what basis?
Sure. So essentially, the Minister of Industry, after consulting with the Minister of Public Safety in this bill, is given the discretion to stop a telecommunication service provider from providing a service to any person or require a provider to suspend service for any amount of time to anybody. So in simpler terms, services can be cut off from anyone at any time if the minister thinks it's necessary to prevent a laundry list of threats that includes interference or manipulation or disruption of a network, but none of those terms are actually defined in the Act. So for example, if a ransomware incident is correctly traced to an IP address, the person at that address could be cut off from the internet. But if the investigation is faulty and the ransomware incident is incorrectly traced, that misidentified person could also be cut off. And then because the minister can issue these orders in secret, if he chooses, it might not be allowable for the internet service provider to even tell the individual why they've been cut off, which obviously is going to make it very difficult for that person to dispute the charges and clear their name and get reconnected to the world.
Wow, and that has really, really serious implications if all of your service has been cut off and you have no idea why and you have no way of getting it reinstated. Rosa, anything you want to add to that concern?
Brenda raises some really great points. And what's really important here is the secrecy that shrouds this entire bill. So our telecom providers are actually forbidden from adequately informing their customers if they have been cut off, why they have been cut off, what has forced them to do so. There's a real concern that these secret disconnection orders might impact people who have a smart device like a toaster or a television that has been co-opted through a cyber attack through no fault of their own. And they may see their internet cut off without any understanding of why that's happened and very little accountability if they choose to appeal that decision and try to find out more information about why their services have been disconnected.
Wow. So Rosa, you've also raised concerns that Bill C26 empowers the government to collect broad categories of information and about how that information can be used. So what types of information are you talking about? And how would this be different from information that telecoms are already collecting? And why should we be worried? I mean, telecoms already have a lot of our information.
Right. I mean, that's a big concern. We're talking about the most intimate details of our life. You know, we all know that we use our digital devices to conduct aspects of our lives, to keep in touch with loved ones, to, you know, have video chats, to email, and then also for our essential services like our health documents, our finances, our education, information about our children and our children's identity. So the bill puts all of these things within the scope of Canada's spy agencies and their partner organizations around the world in ways that we've actually never seen before.
Wow.
So all that information we're talking about, your bank, your credit union, your telecom provider, your energy provider, all of that would fall under Bill C26 and would be accountable to CSE, which is Canada's spy agency, which already operates with very little accountability.
Brenda, one of the things that you have pointed out is that the changes in Bill C26 would authorize the use of secret evidence in court. So can you explain how that proposal would work?
Sure. So there are provisions in the bill for a judicial review of a cybersecurity direction. So that's a kind of a safeguard and a bill which is very short of safeguards because it gives those who are accused recourse to challenge orders if they think that they're unreasonable or ungrounded. But the rules around those reviews allow secret evidence to be presented before the judge and hidden from the applicants and the applicants' lawyers. And then the judges are allowed to use that information that's not even provided to the applicant in a security sanitized summary form to help form their decisions. So this is a very national security way of doing things. But even in national security certificate cases under the Immigrant and Refugee Protection Act, we provide for an amicus, who is a special security cleared lawyer who is in on the evidence and acts in the interest of the accused. And while that's an incomplete remedy, at least we do have a court decision that says that it meets the requirements of a fair process, whereas C-26 doesn't meet that requirement. There's no nod to that process.
And certainly the government is aware of these procedures and guardrails that they could have worked into the legislation but didn't. We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing proposed changes to Canada's cybersecurity legislation in Bill C26 and the civil liberties implications of those proposed changes. Now, Rosa, one of the things to note about these proposed changes is the fines and even the potential for imprisonment. And this is part of the concern about lack of guardrails. The proposed law comes with these very steep fines and the potential for imprisonment for non-compliance for either individuals or organizations. Can you tell us briefly at a high level, what are those fines? What's that potential for imprisonment? And what are they for? Like, what guardrails do we need?
Right. So I believe that the fines go up to $15 million.
15 or 50?
15.
Okay. Well, still really high.
still high. And the imprisonment can be up to 5 years with an indictment. Essentially, what OpenMedia wants to see is the same balances that we provide to justice in other matters. So while some change in government powers may be necessary in this new cybersecurity threat environment, with that great power should come great accountability. Canadians need to have a way to understand how these measures are being used, how often, and to what purpose. If a company does not adhere to doing anything or refraining from doing anything, as we've discussed, they're facing really serious repercussions, and there's very little accountability for understanding how that will actually play out.
And Rosa, sorry, some of those fines are going to be for individuals as well. Do you know what the individual fines can go up to?
I believe the individual fines go up to $1 million. In this case, I see Brenda nodding for affirmation. So we're facing either on a company level or on an individual level, massive amounts of money that we're seeing someone face if they're not following these secretive orders that are not being publicly reported, or even in the case of an individual, seeing their access cut off or seeing that fine come through, there's very little understanding of why that may have taken place.
Mm-hmm. Now, Brenda, another criticism that you've raised with the bill is that it grants power without this accountability. This is something Rosa's talked about. But this is specific to the spy agency, an agency a lot of Canadians might not know about. You've called it CSE, it's Communications Security Establishment. And that is our cybersecurity and spy agency. Most notably, Bill C26 would let the CSE obtain and analyze security-related data from federally regulated companies like telecoms. And the CSE's use of this information wouldn't be constrained to the cybersecurity mandate. So can you give me an example of what that might look like and why people should be worried?
Yeah, so the CSE, of course, has a piece of its mandate under its own governing act that requires it to play a role in cybersecurity and information assurance in Canada. As our signals intelligence agency, that makes sense. They've got that expertise. But this bill mandates CSE be given a lot of information generated as a consequence of a ministerial order because they're a designated body to receive that information. So they're going to get information both from regulators and from companies who are reporting breaches. And a concern that you gave a nod to in the asking of this question is that the CSE cybersecurity isn't just the CSE's only mandate. Under their own act, their mandate is multi-pronged, and it includes active and defensive cyber activities. So in other words, hacking other governments for intelligence or for defense purposes and protecting Canada from those kind of attacks. Again, a very important role. But when they're getting all of this information about breaches, it's very likely to expose previously unknown vulnerabilities in programs that companies and that we all, as ordinary computer users, rely on. And we'd expect under a cybersecurity mandate that when such information is revealed, the CSE would want to fix it. But there's a conflict in their dual mandates because they also might have good reason to want to stockpile those vulnerabilities to exploit them. So at CCLA, we think that with the CSE mandated in C26 to be the recipient of all of this information, there should also be a provision in the bill to require it be used strictly within their cybersecurity mandate, which would require efforts to close gaps in security identified by these breaches, not sit on them in case they might be useful later.
So Rosa, we've only got about 30 seconds. Your organization sent this letter to Minister Mendocino. Has there been any response?
No, we have not received a response from the minister. So the bill's been through its first reading and has yet to be read a second time and has been referred to the National Security Committee for further study. So that's where we're sitting with it right now.
Welcome back to Canadian Justice, where we're discussing Cybersecurity Bill C26, proposed changes to some federal legislation, and the civil liberties implications of that legislation. Now, Rosa, this bill raises the classic debate about security versus freedom. And you have both raised that cybersecurity is obviously a very important issue, but so are civil liberties. So what principle do you want people to keep in mind when they think about that tension?
So security and freedom are not a zero-sum game. We can have both. People in Canada deserve cybersecurity protections without the creation of overly broad and sweeping new powers for elected officials that circumvent our accepted democratic norms. No system is perfect, but we've fought really hard for a balance of interests that broadly work in our regular justice system, and we shouldn't throw all of that out. Cybersecurity, transparency, and accountability can all fit together without any major sacrifice to our civil liberties. And Bill C26 can find this balance, but we need major amendments in order to do so.
Brenda, same question to you. What do you want people to keep in mind when thinking of a tension between privacy and freedom and national security on the other hand?
I completely agree with Rosa. Security versus freedom is a false dichotomy. Because genuine safety and security require individuals not just to be safe from malicious actors online, we also need to be safe from unreasonable intrusion by our governments. It's a tough balance, but it's a balance our democracy requires. And it's entirely reasonable that there be provisions around secrecy necessary when it comes to cybersecurity and protecting critical infrastructures. But at the same time, this act is so positioned within a national security framework that the national security obsession with secrecy is getting in the way of the really necessary, fundamentally necessary accountability. And the fix for the secrecy conundrum is to provide provisions for solid, mandatory, ideally real-time oversight and review, and a public reporting framework that of course can leave out operational details that need to be secret, but reports at the level of policy and impact. So we have a sunlight check on these powers, and the public has a genuine means to assess how the powers are being exercised, how often, and what the impacts are.
So well said by both of you. I completely agree, which is why all our organizations signed this open letter. Rosa, you mentioned that you think that this bill actually could do the job of striking this balance. So do you believe the bill is salvageable, can be tweaked, or does it, do they have to go back to the drawing board?
Right. Well, firstly, I want to point to something that Brenda said, which is that we need, freedom not only from cybersecurity attacks, but also freedom from that intense oversight that we're looking at from our government. That's an excellent point. We do believe this bill is salvageable. Cybersecurity is important, and we want to see our government get this right. We really hope that all our members of parliament from all parties are listening carefully to our concerns and are willing to make changes to this legislation. We can fix this bill so that it delivers strong cybersecurity protections while safeguarding our basic rights. And at OpenMedia, we'll be working with our MPs to make sure that they hear the voices of people in Canada loud and clear.
Brenda, anything you want to add to that? Can this bill be tweaked and amended in a way that strikes the balance a little better, or do you think it needs to start over?
That's a difficult question because whether or not it's salvageable fundamentally depends on whether there's political will to make some fairly substantial amendments. This bill is lacking human rights and privacy protections, which is problematic alongside all the provisions for expanded information collection and sharing requirements. There's no defined role for the Office of the Privacy Commissioner of Canada in this bill, despite all of that expanded information sharing. There's no limits, as we talked about, to CSE acting within the scope of its information security mandate. There's inadequate oversight. There's no adequate public reporting. All of those are massive gaps. They could be fixed by amendment, but we'll have to see whether or not there's the will to do that.
Brenda, we've only got 30 seconds. Do you think if the bill were to pass in its current form, there would be an angle for legal challenge? If some of the actions were taken in some of these secret use of evidence, things like that.
I think it's certainly possible that organizations like mine, and I'm sure yours, would be looking very closely, not just at the provisions of the bill, but around any sort of kind of impacts that we can determine to see whether or not there would be that avenue for legal action.
That's all the time we have. I want to thank you both so much for coming on.
Thanks so much for having us.
We've heard today about the proposed changes to cybersecurity laws in Canada and the civil liberties and privacy implications of those changes. How do we balance liberty and security? And does this legislation need to get amended to get that balance right, or scrapped altogether? You be the judge. I'm Christine, and remember, a freer Canada starts with you.